it is time to get started. And we're going to start. So I'm going to share my screen and cross my fingers to the PowerPoint gods that everything is visible to everyone. Perfect. All right. So let's get going. Welcome to our virtual symposium. Bonjour. Good morning, good afternoon. My name is Benedict Schopflin. I'm the Executive Director of the Canadian Network for the Prevention of Elder Abuse. And I would like to welcome you to our virtual symposium, Restoring Dignity, Addressing Coercive Control of Older Adults in Canada. Before we officially launch into today's program or into even talking logistics, I wanted to provide our land acknowledgement in the name of CNPEA and our partners, Elder Abuse Prevention Ontario and Dementia Justice Canada. We wish to recognize and honor the traditional territories upon which we all live, work, and play. We are gathered together today on the traditional territories of a number of First Nations, and we want to acknowledge their stewardship of this land and of its waters as protectors of its natural abundance throughout the ages. Throughout our work and our daily actions, we seek a new relationship with the original peoples of this land that remains their home to this day. May this relationship be one of peace and friendship based on honor and deep respect. Now, a couple of tech reminders for everyone. We have to do this. I know it's ritual. This is just to help you have the most optimal experience of the webinar or the symposium, of course. So as you will notice, your microphones and cameras for as attendees are off. You do have other options to communicate, which I will explain. We have a team of ASL interpreters today with us, which is wonderful. They will be on screen at all times. You have an option to change how you view things on your screen, either through seeing the speaker or seeing things as a gallery layout. So if you look at your screen, you should be able to see a little grid icon at the top right corner of your screen, and that allows you to choose the layout for your screen. Closed captioning, you can enable or disable closed captioning on your own screen by clicking on the little CC at the bottom of your screen. And if you cannot find it, or if for some reason it's not working, we do have our wonderful partner EAPO behind the scene. Rayanne is there to help, so you can send her a quick little message to chat. Speaking of chat box, you know how that works. You're welcome to post comments during the session. You can engage with each other. You can leave some information in there. There's a Q&A box, which is a separate option if you have questions for our presenters, and we'll address them at the end. So today, the first few presentations in the morning are going to be fairly swift, but there will be plenty of time for Q&A at the end of our panel later on at the end of the event. The presentations are being recorded, so this entire event will be made available online we're saying next week, cross our fingers, and you will be able to find the recording on the website of CNPEA, of Elder Abuse Prevention Ontario, and of Dementia Justice. And the PowerPoints, where there are PowerPoints today, will also be posted on our website, so you can always revisit the information and the links and documents that were mentioned today at a later date. And finally, I want to say a big thank you. We have a lot of you who did our pre-event survey that is massively helpful. We'll be, of course, also sharing a post-event survey. It's very short and easy. We highly encourage you to share your views about what you've learned today, your thoughts, suggestions for future conferences. All of this matters to us. So you can either use the little pop-up link that will happen today after the event finishes, or share your view through the link when you'll get an email notice after the event. And we'll also share that link in the chat box a little bit later. So you'll have plenty of opportunities to tell us what you think. A couple of warnings. your privacy and confidentiality matter to us. And so we appreciate that some of you might have some personal stories that you want to share, circumstances you want to, ask questions about. We highly encourage you not to do this in the chat box because that's still a public forum. We would rather you ask general questions through the Q&A box that is related to the presentations today. If you wish to discuss specific personal circumstances, you can contact me at CNPEA or Rayanne Rideout at EAPO. Their contact information is in the corner of the screen here. And then we can set up a confidential conversation to share more info. And also, you all know what the topic of today's symposium is. It's going to include discussions about really difficult topics. It can be quite triggering for some. So we always encourage you to prioritize your well-being. Feel free to step away and leave at any point. You can get back in whenever you want through the same easy link. We've also shared a couple of useful resources if you want to find support in your area. Now, this said, I know it's a lot of information up front. I think it's time to begin. So I'm just going to stop sharing my screen for a brief moment. Perfect, I think. There we go. And yeah, I really wanted to take a minute to thank you for joining us for this national symposium on coercive control of older people. Today's event is taking place with the support of Justice Canada to mark Victim and Survivors of Crime Week. So there are plenty of events taking place this week. Let's use this time today as a time to reflect on how we respond and support older people in our communities and how we bridge gaps across sectors. Coercive control, as many of you know, is increasingly recognized as a serious and complex form of abuse. Yet, when it affects older people, it's insufficiently understood and very often overlooked. It can take place for older people in an intimate setting, in a family setting, in social relationships, and it's often shaped by dynamics like caregiving, disability, dependence, social isolation. So it does not always look the way we expect, and that makes it really hard to recognize and harder to address. So at CNPEA, we see the symposium as an opportunity to help close that gap. So our goal today together is to mobilize knowledge, spark some reflection, and strengthen our collective response to coercive control in later life. And I want to say a big thanks to our partners, Elder Abuse Prevention Ontario and Dementia Justice Canada, because with their help, we've brought together a diverse group of speakers from across the country and even beyond, all the way from Australia. And they're going to be offering a different lens on the issue. So a brief overview of the program today, if you haven't looked at it, we'll begin with Professor Margaret Hall, who's going to explore coercive control as a form of elder abuse within intergenerational family contexts to help us understand how these dynamics take shape in later life. Then we'll hear from Heather Campbell-Pope, who will provide a short legislative update on efforts to criminalize coercive control through proposed Bill C-16 and whether and how coercive control of older people factors in. And then we'll hear it will be a recorded presentation from Professor Mary Bernoth and Dr. Helen Hickson, who will share perspectives from Australia and highlight shared challenges and opportunities for learning across countries. Then we'll do a short break because it's a lot, and we'll move into a panel discussion to explore the hidden realities of coercive control in later life and what it takes to respond effectively across system, professions, and communities. So I want to say I'm aware that you're coming from very different sectors and walks of life. So whether you're joining as a justice professional, a policymaker, a service provider, or a community member at large, your presence matters. It's a complex issue, and I think meaningful change is going to require shared awareness, collaboration, and action. So thank you for being here. Thank you for your commitment in supporting older people in our communities. And I think with this, I'll stop speaking and welcome Margaret Hall to the room. Margaret, if you want to turn on your screen. Perfect. All you
Okay, good morning, everyone. I've got some slides to share. Okay. Oh, hold on a moment. All right, so good morning, and I want to thank you very much for inviting me to participate. This is a subject that's very important to me. So my subject today is coercive control as a particular form of elder abuse. So important to emphasize that elder abuse does not always take the form of coercive control. So it is a very specific type of elder abuse. And I'm going to focus in particular on coercive control in intergenerational family contexts. The use of coercive control as a means of elder abuse has been explicitly identified by the government in England and Wales, and that underlies their decision, as explained in their policy documents, to identify family relationships in addition to intimate partner relationships as meeting the criteria required for the criminal offense of coercive control in that jurisdiction. So I'm going to start off today by briefly describing the proposed Canadian criminal offense, and I emphasize brief because I know that Heather will be providing more detail about that. Before I turn to the meaning of coercive control as a distinctive pattern of behavior through which perpetrators seek to control their victims for the purpose of extracting benefits. So that's kind of the essence of coercive control. That's its pith, its substance, as it then sort of plays out across different contexts. So the proposed criminal offense currently under review would apply to coercive and controlling behavior carried out with the intent to cause an intimate partner to believe that their safety is threatened or being reckless about causing that effect. So it's confined at present to that intimate partner context. The legislation goes on to identify certain behaviors as coercive and controlling, together with this broad category of any other conduct that, in all the circumstances, could reasonably be expected to cause the intimate partner to believe their safety is threatened. So that very broad provision reflects the reality that coercive control behaviors are not kind of limited in their kind or indeed in their number. Now, the requirement that this behavior be directed at an intimate partner is what I call a relationship criteria. And the relationship criteria is a really important feature and a distinctive feature of a coercive control criminal offense. It's very unusual. The great majority of criminal offenses are conduct focused and relationship neutral. So think about assault, for example, right? If we looked in the criminal code at the definition of assault, we'd see that it is very conduct focused and the relationship between the perpetrator and the victim is irrelevant. Now, that relationship in these sort of relationship neutral offenses could be taken into account in sentencing, but with very few exceptions, it's not a required element of the offense itself. So why do we have a relationship criteria in coercive control? A relationship criteria is included in all jurisdictions that have a criminal offense of coercive control. And that criteria, that requirement, reflects this fundamental nature of coercive control as what's been called a capture crime, in which the relationship itself provides the means of capture. So in this way, coercive control is more like hostage taking or cult exploitation than a crime of passion, right? As domestic violence is sometimes constructed. And indeed, coercive control in intimate partner contexts has been described as a cult of one, in which the perpetrator takes the role of the cult leader and kind of cultivates this relationship of sort of perceptual distortion with the victim that really enables the exploitation to take place. In cult and intimate partner contexts, perpetrators have to work hard to build a relationship that they can then use or leverage in order to extract benefits from their victim. So those familiar with this more general concept of coercive control may have heard of this concept of love bombing, in which the perpetrator sort of starts to construct this relationship through this kind of excessive love bombing kind of behavior for the purpose of building a relationship that then can then be used for these exploitative purposes. Now, recognizing the dependence of perpetrators on their victims for the benefits that they get out of coercive control is really crucial, right? So we often think about domestic violence relationships broadly as ones in which the victim's dependence on the perpetrator is the defining feature, making the victim unable to extricate themselves. But it's important to realize that perpetrators of coercive control construct these relationships for a purpose, that is, to exploit those relationships and extract benefits from them. So they are actually dependent on maintaining that relationship for the purpose of keeping the exploitation going. And this explains their determination to maintain that control, maintain that relationship through whatever means possible. The essence of the behavior is that control through coercive techniques of various kinds, rather than the techniques themselves. So again, this is distinct from relationship neutral offenses such as assault. Now, for this reason, physical violence, and this includes lethal violence, is most likely if and when the victim attempts to extricate themselves or otherwise escape the control relationship and exert their autonomy. Sort of the last desperate move of the perpetrator to maintain that control when other more covert means of maintaining it are seen to have failed. Otherwise, the perpetrator prefers more covert means as more desirable. And those covert means include shame, psychological manipulation, or gaslighting. These are preferred, first of all, because they're less likely to be noticed by others who might intervene in some way. And they're also less likely to push the victim to resist. So an act of physical violence is much less easy to rationalize than these other kinds of more covert behaviors. The relationship itself works to mask the control and also the predatory motives of the perpetrator. So behaviors that would be unacceptable in a stranger, for example, we'd obviously see that these behaviors were wrong, may be rationalized in a loved one. So this is what we mean by cognitive dissonance. Everyone wants to believe that their partner really does love them. No one wants to realize that they're being exploited through the use of techniques designed to grind down their self-esteem, autonomy, and ability to resist until it becomes impossible to rationalize. Now, the proposed criminal offense is a response to several high-profile cases in which women attempting to extricate themselves were murdered by their coercive and controlling partners. And some incidents have gone beyond the victim themselves to include family massacres and community mass killings. So coercive control has been linked to that terrible episode in Nova Scotia, for example. So because of these events, in intimate partner context, the link between coercive control and lethal violence is now clear and established. I don't think anybody can dispute that. And the purpose of the offense is to enable intervention prior to the lethal violence stage to prevent future occurrences of that kind. The criminal offense in England and Wales, and also in Queensland, and I guess we'll hear more about that later, also recognizes family relationships as meeting the relationship criteria for coercive control. And government literature in England and Wales, as I commented on earlier, refers explicitly to coercive control in family relationships as a common form of elder abuse, not just a form of elder abuse, but a very typical form of elder abuse. And so that's why they've expanded the scope of the offense. Now, in my opinion, the relationship between an older parent and adult child in particular is especially vulnerable to coercive control exploitation of the kind I've been describing. So unlike romantic partners, parents don't need to be enticed into these relationships with their children. So remember, I referred to perpetrators using love bombing and similar techniques to really construct the kind of relationship that can then later be used for this purpose. But the parent-child relationship provides a pre-existing mechanism or vehicle for capture and control by an adult child who seeks to use the relationship for that purpose. And of course, most adult children will not be seeking to use their relationship with their parent for that purpose, but some do. And we have to acknowledge that fact and not be too romantic about it. The privileges that can be obtained through coercive control in this context are primarily material, but may also include services more broadly, housekeeping services, housing is significant in this context, may also provide psychological and emotional benefit, and in some cases do include sexual exploitation. Now, because parents are much less likely to leave, which would require cutting off the adult child, and more likely to excuse, and this is a function of the parent-child relationship, I think especially the mother-child relationship. And because there's more shame, more personal shame involved, if your own child mistreats you, then you think not only does that reflect poorly on the adult child, but it reflects poorly on you. You know, what kind of a parent could you have been if your child is going to treat you in this way, is sort of a common theme coming through here. That trigger for lethality is less likely to be pulled. And that's the reason why we don't see that same stark connection between lethality and coercive control in these intergenerational family contexts as we do in the intimate partner context. So just a reminder that lethality trigger happens most often when the intimate partner attempts to extricate themselves from that relationship. So what I'm saying here is a parent is much less likely for all of these reasons to extricate themselves from that family relationship. And furthermore, leaving in this context will often entail leaving one's own home. And in many cases, that's going to be the perpetrator's goal, right? Their expectation is they would like to secure their parents' residence. Perhaps they can't see any other way of securing somewhere to live. So yeah, pushing the parent out of their own home might be exactly what they're going for. It's victim health issues. There's a number of very interesting cases like this that in the end are what bring outside intervention, a sort of forcing an end to the coercive control where health authorities become involved, for example, and in which case the removal of the parent into setting away from the perpetrator in a secure space is what might actually sort of create the psychological conditions necessary to end that relationship. Now, despite this sort of relative absence of a clear connection between coercive control and lethality, in this family context, the suffering caused by coercive control as a form of elder abuse may nevertheless be extreme. So we shouldn't minimize it because that clear connection to lethality is not present in the same way. Now, why do we need a new offense, a new criminal offense for this? Don't we have sort of existing criminal offenses that we could apply to this behavior, or are there other means through other pieces of legislation of dealing with this? Well, the new offense provides a way of understanding and explaining behavior that I think would otherwise not be caught by existing crimes, and provides a mechanism for intervening in these situations before perhaps a person's health declines to the extent that health authorities become involved. The victim, by very reason of the perpetrator's coercive control, is unlikely to be able to seek help independently and very likely to continue rationalizing the abusive behavior of their adult child to outsiders out of shame, intimidation, and love. Those reasons I was describing on the previous slide. Isolation of the victim is also key to the perpetrator's success. Success here in quotes, of course, success from their perspective. And this includes isolation from necessary health care to the extent that they're able to keep this going, may finally reach to the point that they cannot resist health intervention any longer, but they will as long as they're possible because they realize that healthcare intervention is what is most likely to bring this exploitation to an end. So for older adults, especially, isolation makes unilateral self-help extremely unlikely. So I want to conclude with this quote that was very striking to me. It comes from this work, Coercive Control, How Men Entrap Women in Personal Life, by the forensic social worker Evan Stark. And Evan Stark was one of the first to describe and explain coercive control as a distinct form of abuse. Stark turned the question, why don't women leave, implying a masochistic enjoyment of coercive control relationships, on its head. So in Stark's experience as a social worker, and this is kind of where he's coming from, he was sort of seeing this pattern repeating out there and sought to try and make sense of it and explain it and put some language around it. For Stark, the real focus lay in the absolute determination on the part of perpetrators to hang on to the source for which they were dependent. For sex, for money, for a home, for someone to take care of them, by any means necessary, including ultimately with the threat of lethal violence. Now, I firmly believe, this observation is equally applicable to the adult child who uses the means of coercive control to leverage the filial relationship dynamics to achieve many of the same benefits. Isolating their parent to exclude interference by others who might destabilize that dynamics, using techniques of intimidation, shame, and threats to keep control of benefits they cannot acquire otherwise. So for these reasons, I personally welcome the criminalization of intimate partner coercive control in Canada, and I also support expanding the scope of the relationship criteria within that criminal offense to include family relationships, thereby allowing the offense to be used as a means of intervening in coercive control elder abuse for the protection of victims' lives, their sanity, and their well-being. So thank you for your attention and listening to me today. And I'd love to talk about these issues with you further. So if you're interested in continuing the conversation, please don't hesitate to be in touch. And my contact information is given here.
Thank you so much, Margaret. That was great. And we made great time. We have a few minutes to spare. question for you, and I don't want to put you on the spot, but someone has said, can we ask Margaret a question? Are you
Yes,
willing to take a question from the audience right now? Is it okay?
yes, certainly.
Okay. So if to the person who asked, you have a couple of minutes, you can type your question in the Q&A box, and we'll try to tackle this right now. And there is one person, I'm going back through the chat box, and I assured her we're going to deal with this question in the panel, but maybe you have an answer. Um, she asked, Deirdre asked, how do you prove covert control? Because so often these people present themselves as truly loving individuals.
Well, that in a way is the million-dollar question. And that's what I would say people who aren't convinced about the criminal offense point to, is that it is very difficult to, in some cases, collect the evidence necessary to support a criminal charge. And in fact, in many cases, and this kind of makes it even more difficult, the victim of coercive control, until they get outside the relationship, it's like, they say a fish swimming in water doesn't see the water, cannot sort of see or understand the dynamics. That's the sense in which this is described as sort of a cult of one, right? Like a person inside the cult does not see that they are a victim of cult exploitation. So they themselves may sort of try and disguise some of these behaviors. But it is, so it's difficult. And I think we shouldn't sort of shy away from that difficulty. But it has sort of proven possible in jurisdictions that do have these criminal offense to kind of marshal sufficient evidence to proceed. And when they do, the behaviors are intended to be covert and secretive, but they're not subtle, if that distinction makes sense. So if other individuals, maybe family members, neighbors, employers, people in the workplace, are able to sort of see and take note of and provide evidence about these behaviors, then that evidence can support a criminal charge. But we can't deny that there will be many, I would say, successfully secretive or covert incidents of coercive control where that evidence is just too difficult to marshal. Another distinctive evidence of the or characteristic of this is, of course, perpetrators know this and understand this, right? So they're going to do everything they can to maintain the secrecy. Secrecy is a huge part of this. And shame is a huge tool in their arsenal for keeping this situation secret. So in the elder abuse context, it would be, well, of course, we all want to present our children in their best light, right? My son is doing X. My daughter is doing Y. Nobody wants to reveal that, some quite extreme behaviors may be going on behind closed doors. So that's the dynamic. I hope that sufficiently answers your question.
Thank you so much for this. And I think so. Again, a reminder to our audience, if you can put your questions in the Q&A box so we can keep track of them more easily, that'll be wonderful. I did see one go through, someone asking, does this manifest as well in same-sex couples? And I don't know if there's a lot of data out there on this.
Well, there actually is. And so
Ah,
this is explicitly addressed in that legislative guidance from England and Wales. So yeah, it's I guess the nature of the romantic relationship, regardless of kind of who's involved in, gender-wise in that romantic relationship, is what provides the vehicle or the mechanism for this. Just like in the elder abuse context, it's the nature of that parent-child relationship that provides the vehicle or the mechanism for this. So obviously, if when Evan Stark was writing, he very much connected this to sort of the male-female dynamic. But since that time,
Oh, we've lost your sound,
we
Margaret.
have,
Oh, there we go.
oh,
No, it's back. Sorry.
are you okay?
Yes,
Yeah.
we're good.
Since that time, it's also been explored in same-sex relationships. I'm going to say this. I don't know if anybody but me ever watches Coronation Street, but they have actually had a couple of very vivid, very realistic coercive control storylines. And when they have at the moment does involve a same-sex couple relationship
You
that
know
I
things are
think,
changing when it's on TV.
yeah, really illustrates
Yeah.
just sort of the nature of these dynamics, including covert dynamics.
Wonderful. Thank you so much, Margaret, for taking those questions on the fly. It was well worth it. And thank you for
Oh,
this wonderful presentation.
you're welcome. I
Oh,
see another Coronation Street viewer there.
On this note, I think we're going to invite our next speaker, Heather Campbell-Pope, who will take over from kind of expanding on some of the points that you, Margaret, mentioned today about the proposed legislation. So thank you, Margaret, so much. And Heather, welcome. Um, I'm going to let you take over from here, go off camera, and I guess you have 20 minutes.
Great. Well, thank you, Benedict. So my aim today is to provide a snapshot of where things stand in Canada with respect to criminalizing coercive control. So just so you're not looking for them, I will be giving my talk today without slides. So as we heard from Professor Hall, this issue is now being debated in Parliament through Bill C-16, the Protecting Victims Act, which the Federal Justice Minister introduced in December of last year. So the bill proposes, among other reforms, a new offense in the criminal code that would criminalize a pattern of coercive or controlling conduct toward an intimate partner. Now, I did see in the chat box there a question about what is an intimate partner. So I will just pause here and define that, because in Canada, that term is actually defined in Section 2 of our criminal code for the purposes of criminal law. So it's defined as a current or former spouse, common law partner, and dating partner. So to help place this proposed offense in context, I'm going to do three things. First, I will provide some legislative history where we'll look at previous attempts over the last several years to create a coercive control offense here in Canada. Then I will turn to C-16 itself, and I'm going to pay particular attention to aspects of the offense that make it perhaps constitutionally vulnerable. And finally, I will look at where C-16 stands today and where it's likely going next. Now, before I get to that, I just want to preface my remarks with a few points. So first, my talk today is intended as general information only, and it should not be taken as legal advice. And second, I do want to clarify what I will not be discussing today. So as you may know, there are parallel developments occurring in civil law. So for example, on Friday of this week, the Supreme Court of Canada is expected to release its decision in Ahluwalia and Ahluwalia on whether to recognize a tort of family violence or maybe leave the door open for a narrower tort of coercive control in family law proceedings. Now, it will be interesting to see how this decision may later be considered in the elder abuse context, but that's beyond my talk today. So with that in mind, I'll now turn to my main remarks about criminalizing coercive control. So Bill C-16 is actually a very large bill. It's over 160 pages long, and it proposes other criminal reforms in addition to the creation of a standalone coercive control offense. So to place what is happening in Canada in a global context, and in my view, and to echo what Professor Hall was saying, is I think it shows not only is Canada late to the game, but it's now also falling behind contemporary understandings of coercive control. Let's look at a few developments from abroad. So the first jurisdiction to criminalize coercive control was England and Wales, and they did so in 2015 through Section 76 of its Serious Crime Act. There, the maximum penalty is 5 years in prison. The offense applies to a victim and suspect who are what's called personally connected. So generally speaking, this includes intimate partners and family members. Now, originally, that offense was limited to those who live together. But in 2023, legislators removed that cohabitation requirement because they recognize that coercive control can continue after separation. Now, that amendment is also relevant to the elder abuse context, where, for example, an adult child may be exerting control over an older parent while not living in the same house. Now, I'll also mention Scotland because it's referred to by many advocates as the gold standard for criminalizing coercive control. But it only applies to partners and ex-partners. It's been in place since 2019, and in my view, is also out of step with the growing recognition that coercive control occurs in wider family and caregiving relationships. Now, other jurisdictions have also moved to criminalize coercive control. For example, we'll hear next from our speakers in Australia about the experiences there. So in Canada, formal legislative efforts to criminalize coercive control began 5 years ago in 2020, when NDP MP Randall Garrison introduced a private member's bill, Bill C-247. This offense would have applied to persons who are connected, which you will recognize as similar terminology to England and Wales' phrase of personally connected persons. So generally speaking, the scope would have included current spouses, common law partners, dating partners, and those who are engaged. If they were now partners, the offense would have only applied to all those categories if the couple still lived together. And importantly, for our purpose today, Mr. Garrison's proposal would have also included the broader category of relatives, with the caveat that the perpetrator and victim live together. Now, who is a relative? Well, that term was not defined, but if we look at other existing offenses, like intimidation in Section 423 of the Criminal Code, we see that the term relative is undefined, but we can turn to the common law to see how it's been interpreted. Now, nevertheless, Mr. Garrison's bill did not proceed beyond first reading. He tried again in 2021 with a substantially similar bill. This was Bill C-202. It met the same fate, only completing first reading. Then, building on the momentum generated by Mr. Garrison, we see some significant progress in 2023, when his colleague from the NDP, MP Laurel Collins, introduced Bill C-332. Now, its evolution is interesting. At first reading, the offense would have applied, like Mr. Garrison's bill, to persons who are connected. So again, meaning current partners or former partners and relatives who live together. This bill passed second reading and advanced to the Justice and Human Rights Committee. But then the government proposed amendments that significantly altered the offense by narrowing it so it only applied to intimate partners and eliminating its application to the wider family context. So in effect, they erased elder abuse victims from its scope. The Justice Committee adopted that change, and the narrow version of the bill went back to the House, where it passed third reading with unanimous all-party support. Then at the Senate, it received second reading and was referred to the Committee on Legal and Constitutional Affairs. But before that committee could begin its study, Prime Minister Trudeau prorogued Parliament in January of 2025. Now, interestingly, that actually didn't immediately kill that bill because private members' bills actually survived prorogation. But then 2 months later, Mark Carney dissolved Parliament for the federal election. And that meant Bill C-332 died on the order paper. And any new attempt to criminalize coercive control would have to start from scratch. So once Parliament resumed after the election, I think many of us were anticipating another private member's bill, given that the NDP was signaling that it was working on improving Bill C-332. I was hopeful that this would include the original wider scope where it would have also applied to relatives. But that did not materialize. Instead, what we see in December 2025, the Justice Minister introduced C-16. It picks up where C-332 left off. That is, it is limited to intimate partners. So let's look closely at this proposed offense. So first, as I said, the scope is specific to intimate partners, which we've defined in Section 2 of the Criminal Code. Second, it is a hybrid offense. So this means the Crown can proceed summarily or by indictment. And in those latter, more serious cases, the maximum penalty would be up to 10 years in prison. Now, Professor Hall shared the language of the offense, but I'm going to read it again because it's quite tricky to just paraphrase. So bear with me as I read it. Everyone commits an offense who engages in a pattern of coercive or controlling conduct referred to in subsection 2, which we will turn to, with intent to cause their intimate partner to believe that the intimate partner's safety is threatened, or knowing that, or being reckless as to whether the pattern of coercive or controlling conduct would cause their intimate partner to believe that the intimate partner's safety is threatened. Okay, so crimes consist of two elements: the actus reus, or the physical element, which is often a physical act or omission, and the mens rea, which is the mental element. So intent, knowledge, recklessness, willful blindness. Looking at the first element, the actus reus, C-16 lists, for the coercive control offense, lists a number of actions that any combination of which or repeated instances would count as coercive control. So generally speaking, these would include using or threatening to use violence and coercing or attempting to coerce a partner into sexual activity. Then the proposed offense lists their actions that would count if they could reasonably be expected to cause the victim to believe that their safety is threatened or that the safety of someone they know is threatened. Now, generally speaking, these include controlling the victim's movements, social interactions, how they care for their children or pets, controlling their employment, education, finances, property, physical appearance, diet, medication, access to health services, and access to the religious and cultural communities. It also includes threatening to die by suicide or threatening to self-harm. Now, a concern, especially from a defense perspective, is what does a pattern or repeated instances mean? For example, would 2 actions be enough for a conviction, or is something more continuous required? Now, if we look to case law as well as sort of international legislative guidance, that would suggest that 2 instances may be enough in some situations. Now, turning to the mental element of the offense, C16 includes both specific intent and recklessness. So here we see concerns that recklessness may be too low of a threshold and that the higher burden of proof of specific intent should be required. That is, that the accused actually intended to cause their partner to fear for their safety, not just that they were reckless as to whether their partner would have this fear. So I think we're likely to see that these constitutional vulnerabilities will be challenged in court if C16 as drafted becomes law. So back to where things stand procedurally in Parliament. So earlier this year, in February, C16 passed second reading in the House and was referred to the Justice Committee for further study. So there, a number of organizations, including Dementia Justice and many others working in the elder justice space, made written submissions or appeared as witnesses to raise the concern about the narrow scope of the offense, given that it excludes coercive control perpetrated by relatives, caregivers, and others in relationships of trust and dependence. Now, our committee, during clause by clause consideration, MP Elizabeth May proposed an amendment that would have expanded the scope to relatives, but that amendment was defeated. Instead, the committee adopted an amendment that would require Parliament to review the offence after 5 years. So that would include, among other things, looking at criminalizing coercive control beyond the intimate partner context. So if we do the math, and if the legislation receives royal assent with that review provision, we're likely looking at a review process to start regarding the elder abuse context, to start no sooner than 2031. Now, the government has provided a few rationales for this delay, and I'll talk about one. So the government says, and I think reasonably so, that law enforcement and the wider justice system need time to prepare for this new offense. Fair enough. But the trouble with that reasoning is that there is already a 2-year delay for the offense as it relates to intimate partners. So in other words, if things proceed on schedule, the coercive control offense in relation to intimate partners won't become law until 2028. So my question is, why is the government tacking on an additional 3 years to start to even consider whether to expand to relatives and other relationships? Why not use those existing 2 years to also prepare for the elder abuse context? So in terms of next steps, the bill is likely on its way back to the House of Commons, the whole House of Commons for third reading, where it will likely pass, and then it will move on to the Senate, where further amendments could still be considered. Yeah, you may sense a bit of frustration about C16's narrow scope, and particularly this proposal for a 5-year delay. But amid all this, I do want to emphasize that the law reform around coercive control is constitutional democracy at its finest. So I'll leave you with this thought. As Canadians, we are fortunate to participate in a system where government responds to a grave societal problem tables legislation that can be debated, improved, and when necessary, challenged in the courts. So no matter how slow or frustrating this process may seem, we should not take it for granted, and we should feel very proud of our system. Thank you for your time today.
Thank you so much, Heather. That was excellent. I benefited from that deep overview. Um, I also wanted to say I launched into your presentation really fast, did not introduce you properly. So I've corrected this in the chat box, and I wanted to say out loud, Heather Campbell Pope is the founder of Dementia Justice Canada. As you've heard today, there's a lot of work being done by Dementia Justice Canada, including, but not only, on coercive control and Bill C-16. And if you want to learn more about their work, you can go to dementiajustice.ca. I've put the link into the chat box. I encourage you to check it out. There's some wonderful work taking place thanks to Heather, including the Elder Justice Coalition that has been really focused on this bill for the past few months. So thank you, Heather. It's been a pleasure. You're free, free to go, free to stay with us and listen to the rest of the presentations as you see fit. I'm going to ask Rayanne for a little bit of assistance to launch into our next presentation. Now, as I mentioned earlier in my little welcoming words, the session that we're about to start right now was pre-recorded. And the reason for that is because it is being done by two wonderful speakers from Australia. And, you know, the time difference being what it is, it didn't seem fair to ask them to do a presentation at 3 a.m. their time. So they recorded a 25-minute presentation, which is entitled Two Countries, Shared Challenges, Coercive Control of Older People Through an Australian Lens. Now, in the next few minutes, you're going to get to hear from Associate Professor Marie Bernoth and Dr. Helen Hickson about the realities of coercive control in Australia and the work that is taking place there. So if you give us just a second, I see Rayanne has lined up the recording. We're going to cross our fingers that the sound comes through nice and clear. If there is a little bit of buffer time, give
Hi
it a
everybody, my
second.
name's
It might self-correct. Raring to go. So yes, I'm going to go offline, but we're still here in the back end if you need anything. Enjoy this presentation by Marie Bernoth and Helen Hickson. Thank you.
just checking you heard that little snippet.
We sure did.
Okay.
Helen, and I'm coming to you from University in Australia, and I'm here with Marie. I would like to just start by saying thank you very much to Benedict for inviting us along today. We've got a bit of a presentation which we'll share with you, and so I'll share my screen and we'll get started. So our presentation today is called Two Countries, Shared Challenges, the Coercive Control of Older People Through an Australian Lens. So my name's Helen Hickson. I come to you from Djajarang country in central Victoria near Bendigo, and I'm here with Marie. Marie, do you want to introduce yourself?
Yeah, hello everyone. Thanks for having us with you. My name's Associate Professor Marie Bernoth. I live and work on beautiful Wiradjuri country in Wagga Wagga, New South Wales, and Wagga Wagga is halfway between Sydney and Melbourne inland.
Thanks, Marie. So our presentation today, we're going to cover the research that we've conducted in particularly around older persons, coercive control and older adults. We're going to talk a little bit about the Australian National Plan and the state and territory laws. We'll talk about nomenclature and defining coercive control, where we want to go from here, and then we'd like to share a couple of case studies with you. Marie, let me hand over to you.
We also want to share with you our research. Our research is what this presentation is fairly extensively based on. So with Catherine Hungerford, Denise Blanchard and Heather Lovett, we've conducted research interviewing 9 community members using semi-structured interviews. The reason we have community members as informants is that we struggle to get ethics approval to include those people who have experienced coercive control. So there are ethical dilemmas in here. However, we have had one journal article published and that's there for you to read about. And what we did in that article was do a literature review and from our data come up with a definition of coercive control. And again, it's fairly extensive and includes a lot of aspects of elder abuse. However, I think the standout thing with our definition is that we do not identify a particular group. We understand that it can be from a broad range of individuals.
Thanks, Marie. So Marie's going to talk now about the Australian National Plan to End Abuse and Mistreatment of Older Adults, which has just been released, 2026.
So yes, Helen, that plan has just been released. We did have a number of years without a plan to guide legislation with elder abuse, of maltreatment of older people. Australia's national plan recognises coercive control, but only coercive control is only covered in one page of the document. It's recognised as a core dynamic of family and domestic violence, not only intimate partner violence, but the definition within the plan is still fairly narrow. It presents a shared definition and broadens the scope beyond partners to include family members and carers, but our research showed that that is still not broad enough. There are some significant points in the plan, and it recognises that coercive control is a pattern of abusive behaviours, and it also recognises the intersectional impacts, including age-related vulnerability. However, it doesn't recognise the impact of government legislation and the current government discussions around intergenerational wealth and the potential policies and tax changes the government's going to make that incite intergenerational guilt and inheritance impatience. So I see those aspects as contributing to potential elder abuse. The plan guides states and territories, but it doesn't impact, or it guides law, but it doesn't determine law. Each state and territory has their own laws, and that differs across jurisdictions. And that's similar to what's happening in Canada, I believe.
Thanks, Marie. We've got a slide here which has got a summary of the state and territory laws in Australia. Marie, did you want to talk a little bit about that?
Yeah, Queensland has the most comprehensive law. There has been a number of very serious incidents where coercive control wasn't identified, resulting in the deaths of women and children. Coercive control in Queensland applies to family members and informal and unpaid carers, not just intimate partners. And, you know, we need to identify and recognise that intimate partners and even family members are not the only ones who can coercively control older people. So that's our most extensive law relating to coercive control. However, it hasn't been, the impacts of that law haven't yet been researched or identified. So we're still we're still waiting to see the impact of those laws. In New South Wales, coercive control is an offence, but it's limited to inter-partner relationships. Just in the last few days, the New South Wales government has announced that it will criminalise any tracking or stalking via technology. However, that again has implications because we have people who may have dementia whose family use particular apps and devices to track where they are for their own safety. So again, we need to see the impact of that. That is very, very new. So there's really nothing. There are entities in New South Wales that are charged with protecting the older person. But from our research, we're finding that these entities don't always do what they're legislated to do, and they're not keeping the older person safe in all cases. In other states and territories, we don't have coercive control laws as yet. They're still consulting. And again, there's a perception in the other states and territories that elder abuse is perpetrated by adult children. But there's been some very interesting discussion in Victoria about the dangers of legislation concerning coercive control. Helen, would you talk to that?
Yeah, so I'm involved in a specialist family violence service in Victoria, and we're certainly concerned that coercive control legislation may impact family members and victim survivors, that the law can be flipped so that the people who are trying to help or trying to disrupt what's happening end up being charged under the legislation. And I've got a case study a bit later on that I'll talk about where the daughter who was trying to get some help for her mum was very much at risk of being charged with harassment kind of allegations. So in Victoria, we're really thinking about what's the impact for everybody in the coercive control legislation and trying to just push back on that legislation coming through at the moment. So the next thing that I wanted to talk about was nomenclature. And in our research, we found it was really difficult to come up with a clear idea or understanding about nomenclature. All of the people that we spoke to had different terms that they used to describe coercive control in older adults. And we found that there are lots of different terms that don't quite connect with domestic and family violence language. For example, in DFV, we might talk about perpetrators and we might talk about victim survivors. But in coercive control, the perpetrator might be the son or the daughter or the carer. And the victim survivor doesn't always necessarily fit as easily. And so while there's that lack of clarity and lack of agreement about the terms, it's really difficult to build legislation. There is a lack of understanding in the community about what coercive control is and what it isn't. And it's often caught up in psychological abuse and financial abuse terms. So I've got our definition here again about what we've come up with for the definition of coercive control, and this is something that we're still working on. We've come from this position of talking with the community members of their understanding of coercive control, and we'll talk a bit more about our next steps, and we need to talk to some other groups of people to try and broaden that out and understand what that means. So in the next steps for our research, we are presenting at the Australian Elder Abuse Conference in July on the Gold Coast. We've got a couple of papers being prepared for publication, and one of those papers is around that nomenclature discussion and how the different terms are being used by different people in the community. We've also got some possible areas for our future research. So we really want to talk with older people who've experienced coercive control. We tried to do that in our original study, and we weren't able to get that part through our ethics review stage. So we dropped that bit out, but we want to keep working on how do we talk to people who've experienced coercive control. We want to understand the lens of culture and coercive control. Australia is a very multicultural community. We're interested in what coercive control looks like in diverse cultures and also in First Nations communities. We want to understand the experiences of health services around confidentiality and sharing information. And Marie's written about that. We've got that reference there. And then the other thing that we're working on is mapping legislation so that we can influence policy and make sure that legislation is going to meet the needs of the community. We're also interested in seeking funding and collaborations to support our research. So if you have any questions or have any ideas, please reach out to us either through Benedict or I've got our email addresses on one of those earlier slides. Is there anything you want to add to that, Marie?
No, but would encourage anyone who's seeking to collaborate with us. And there are so many similarities between Australia and Canada. Canada is also multicultural, so I'm sure you're interested in that aspect. And we've done some interviews with people from other cultures, and there's a whole wealth of information, difference, issues that they face with their cultural norms and fitting into a new society, and how vulnerable their older people are. So yeah, we're keen to push this forward.
Thanks, Marie. Well, I just want to finish up the presentation with the references. So Marie's reference is there, the 2014 reference, and then Catherine Hungerford's reference is the 2026. That's our most recent paper about trying to come up with a definition. We've also got the New South Wales paper and then the national plan. So we've got a reference there for that. So I'll stop sharing my screen. And what we thought we would do now is just tell a couple of stories from our research about two people that have the community members who've experienced coercive control. So Marie's going to go first, and then I'll go second.
Okay, so I will do some reading here because this story is my mum's story, and I want to make sure I'm not too emotional and I stay on track. So forgive me if I'm doing some reading. So Mary's story, Mary is actually the reason that I started the research and gathered the research team around us. So Mary's story is an example of a situation where coercive control occurs outside of intimate and family relations, and my desire to see legislation more wide-ranging. Mary was a lady in her 80s who for many years had offered support and accommodation to overseas students attending a local university. All of those have gone on to have successful careers, and many stay in touch with Mary as friends. But the last person who had accommodation in Mary's home was a very different story. She was asked by an agency to take this person on as they were fairly young and didn't have secure accommodation. He was embraced by the family. He took every opportunity to ingratiate himself to the family and be close to the family and to Mary. He also took full advantage of the isolation imposed by COVID and the fact that Mary's family couldn't visit, but he was still in the home. He also took advantage of Mary's obvious deteriorating cognition. He paid no rent. He used Mary's debit card to purchase groceries. She paid for his web access and his phone. He used her car, but Mary paid all expenses relating to the car. Mary gifted him large sums of money for holidays. In her poorer cognition, Mary perceived him more like a lover, and her behaviour towards him was inappropriate, as was her dress. But he encouraged that. Mary's family concerns were met with anger from Mary, and any approaches to him to temper his behaviour resulted in him going back to Mary and saying, "Marie makes me sad," making Mary even more agitated and angry. The entities who are legislated to support older people from elder abuse, they supported Mary's right to spend her money how she wished and denied the concerns of the family. This then caused damage to family relationships, and the board are suffering no consequences for their behaviour. The questions are, as Helen alluded to earlier, is it the family's reaction? Is that the source of angst? Is the family the problem? Is the boarder not committing coercive control of Mary because he's not an intimate partner or family? The only way we could get help with this situation was we eventually found a committed, enthusiastic police officer who was willing to do her job. Helen, after those questions, I will hand over to you.
Thanks so much, Marie. So I'd like to tell you the story about Jessica. So Jessica was one of the people that we interviewed for this study. She heard about the study through a friend, and she wanted to tell us the story about her mum. So Jessica lives in Melbourne. Her mum repartnered after her dad died, and her mum and her new partner moved to a small town in Queensland, which is about 2,000 kilometres away. Over time, it started slowly, where Jessica couldn't get her mum on the phone, and then her mum stopped returning phone calls, and then she wasn't talking on the phone when he was there, and then there was no contact. Jessica had some concerns about her mum's cognition and confusion and questioned whether she might have dementia. This was during COVID, and Jessica was living in Melbourne, COVID central. Jessica wasn't able to travel out of Melbourne, and she certainly couldn't travel into Queensland. She tried everything to see how her mum was to make contact. She reported to police, who said they would do a welfare check. They reported that they'd visited and asked her mum if she was okay and said she seemed to be fine. Jessica asked if the partner was there, and they said yes, he was, but everything seemed to be okay. Jessica called her mum's doctor, who wouldn't provide any information. Jessica and her brother and sister were worried. Nobody lived near her mum, and they were prevented from visiting for extended periods of time due to the COVID travel rules, nearly 2 years before they could visit. Jessica called the elder abuse line for information, and they offered her counselling to help her with her thoughts and feelings about missing her mum. One day, Jessica heard from a neighbour that her mum had had a fall, and the neighbour called an ambulance, and her mum was taken to hospital. Jessica called the hospital, and she talked with a nurse who wouldn't provide any information about her mum. The social worker at the hospital called back and asked Jessica if she had power of attorney or power to make decisions. And when Jessica said no, the social worker said, "We can't tell you anything." There were a number of phone calls back and forth, and the social worker eventually called and said, "Stop calling and harassing our staff." Of course, Jessica didn't stop calling, and one time she called and they put her through to her mum's room, and she was able to talk to her mum. Her mum said she didn't have any idea why she was in hospital or when she would be going home. Eventually, Jessica was able to travel to see her mum, and she went to Queensland. She couldn't find her. She wasn't in the hospital, she wasn't at home, and there was no information about where she was. hospital wouldn't say where she was discharged to. The partner wasn't around, but when Jessica looked inside the windows at home, she found squalor, and she was disgusted at the conditions that her mum had been living in. How could the police do a welfare check and say that this was okay? Through her mum's neighbour, she eventually located her mum in residential aged care in a nearby town, where she'd been admitted for rehab or respite or something. Jessica travelled to the centre and found a nurse who wanted to help. The nurse and the facility supported an application to the Queensland Civil and Administration Tribunal, and Jessica was appointed as a medical decision maker. Jessica's mum stayed in aged care and her husband never came to visit. Then one day the neighbour called to say that he had been found dead in the front garden. Jessica's mum lived in aged care for several years, thriving. Her family, her friends, her neighbour, her children and her grandchildren could visit, and she could talk on the phone and FaceTime her family in Australia and overseas. And Jessica called me just recently to say that her mum had passed away peacefully on New Year's Eve. So we wanted to just share a little bit with you about our research, where we're up to, the stories that we've gathered, and the next steps. It's really lovely to be able to talk with you today. We're really keen to collaborate, but I think right now we are asleep while you are at the symposium. But please contact us. Please reach out if you have any questions or if you want to talk about any of the things that we've raised or anything that we might be able to do together. Maria, any final closing thoughts from you?
Just want to say thank you for inviting us to be part of the symposium. We hope that our contribution has enhanced your understanding of coercive control and the need to continue the conversation about appropriate legislation. Our goal is to ensure that our older people have quality of life and are safe. Thank you.
Thanks so much, Marie. Bye for now, everybody.
All right. Well, I hope you enjoyed this presentation as much as I did. And I know that Marie and Helen will be watching the recording of our symposium at a time that is better suited for them. So I wanted to thank them both for participating and sharing their perspectives, their research. I have added in the chat box the email addresses for Helen and Marie. They have both expressed several times that they were extremely interested in hearing from other, academics, researchers, people who work in the field or on the topic of coercive control, and to hear from Canadian perspectives. So if you do have something that you want to discuss with them or maybe, collaborate with them on something, please do. I know they would welcome this information or this opportunity, rather. A very brief introduction before we launch into our discussion today. Present with us for this great panel today is Joanne Blinko, who is the Executive Director of the Alberta Elder Abuse Awareness Council, also known as AEAAC. Bonnie Brayton, who is the Chief Executive Officer of Disabled Women's Network of Canada, also known as DON Canada. Kurt Goddard, Executive Director, Legal and Public Affairs of Inclusion Canada, and Amy Coupal, who is the CEO of Ontario Caregiver Organization. I hope I did not butcher any of your names. It's always a moment of stress when I realize I did not ask you how to say your names. So together they're going to bring their expertise that's spanning, as you can tell, frontline elder abuse prevention, caregiving, disability rights, legal policy frameworks. And, each of these aspects is critical in understanding how coercive control of older adults affects older adults. So I hope that this conversation is going to help explore these questions and help us understand how, in the context of disability, in the context of family relationships, sometimes systems are not always well equipped to respond. So we'll cover all of this together. And just to give everyone an idea of how we're going to go about it, what I'm going to do is I will I'm going to ask a question and invite specific panelists to start each question. And then, I'm not too rigid. I can open it. So if anybody feels like they would have something to add, feel free to chime in. It's always welcome. Of course, it's also my job to move us along to make sure that we hear from everyone and that we don't go over time. So if need be, I can be stern. But let's get going right away. And to start us off, let's do a collective question. So it's a question for all of you. I'll start with Bonnie, then we'll do Joanne, Amy, and Kurt. From your perspectives, which are very different as we established, what makes coercive control involving older adults different or uniquely complex? How prominent is the issue in your work or the communities you serve as well? I'd love to hear that. So let's start with Bonnie.
Well, first of all, thanks so much again for organizing this conference, Benedicta, and this panel in particular. It's great to see my fellow panelists. I haven't met everybody, but it's good to see my friend Kurt and to meet you other folks. And a really good and important question to open us with. Some of the data that I think is important to consider is that 1 in 6 older adults experience abuse. This is real data, and that half of older adults, especially women, are living with disabilities. So we're not talking about a marginal issue. We're talking about something structurally embedded. For older adults with disabilities, control is often exercised through access to care, finances and benefits, communication and mobility. Many other things, of course, but I think these are ones that would be familiar to most people thinking about this question. So the same systems that are meant to support people can also be used to control them. What makes this complex is in part the life course dimension, because many individuals have experienced violence earlier in life, and that pattern can continue to evolve into elder abuse. And despite this, the issue remains unrecognized because ageism is normalized, dependence, ableism undermines autonomy, and systems still look for incidents, not patterns of control. And I think that's a really important aspect of this. Thank you.
Thank you so much, Bonnie. Joanne, what about you?
Perfect. From the perspective of the Alberta Elder Abuse Awareness Council, coercive controls involving older adults is really uniquely complex because it happens within that context of the relationship that's built on trust, dependency, and long family histories. Coercive control is usually an ongoing pattern of manipulation, intimidation, isolation, financial control, or emotional abuse that slowly limits an older adult's independence and decision-making. What is particularly difficult with older adults is that many factors can overlap, and Bonnie spoke to that. Sometimes declining health, cognitive changes, caregiver dependence, social isolation, grief and loss. For us in rural communities, transportation barriers, and financial vulnerabilities. In many cases, the person causing the harm may be the primary caregiver, the adult child, or someone that the older adult relies on for daily care. This creates enormous fear around reporting because older adults may worry about losing support, housing, financial relationships, or sometimes being placed into a lodge. You cannot divorce your children. We also see that coercive control is often misunderstood or minimized in older populations. Communities may recognize physical abuse more easily, but patterns of intimidation, financial manipulation, or restricting access to services can sometimes go unnoticed for years. In rural or smaller or indigenous communities especially, there's privacy concerns, there's limited services, and there's strong family or community ties that make disclosing very difficult. From our perspective, the issue is highly prominent in the work that we do here in Alberta. Through our case management programs, our coordinated community response networks, and frontline partnerships, we regularly see situations where coercive control is at the core of elder abuse cases, particularly involving finances, decision-making, social isolation, and control over access to healthcare or supports. What is becoming increasingly clear is that coercive control impacts not only safety, but also the dignity, the autonomy, and the quality of life for older adults. Addressing it requires a coordinated, trauma-informed, relationship-based that brings together healthcare, community agencies, law enforcement, legal supports, and families to ensure that older adults are supported without increasing their risk or their isolation. Thank you.
Thanks so much, Joanne, for this answer. And we're going to get into that a little bit later in the panel. Amy, Kurt, I know we don't have a lot of time, but do you have something to add to this question?
Sure, I can. Thanks for having me. I'll add three things. Three things that make coercive control of older adults uniquely complex in our work. So first, the people we work with are often subject to substitute decision-making regimes like guardianship on one end of the spectrum and power of attorney that already remove control over major decisions of daily life. So coercive control then operates on top of a legal structure that has already constrained autonomy. Second, much of the harm is setting based, not just relationship based. So it happens inside group homes, long-term care, and other congregate residential facilities and settings. So like a quick example, imagine a woman with a developmental disability who lives in a group home. Staff control who she sees, when she eats, when she sleeps, and what activities she joins. So the coercion here is it's not in it's not a relationship layered onto something on a normal setting. It's built into the actual operating norms of the setting itself. And the Convention of the Rights, I'll talk about the convention later, calls for some change and reform of these institutions. And third, the harm is often invisible to the people most likely to notice it because what looks like care to outsiders can be coercion to the person living it. So looking forward to the discussion. I'll stop there.
Thank you so much. And Amy, final
Well,
word.
my colleagues have highlighted so many important items. I'm just going to add a couple, which is to underscore how prevalent caregiving is across Canada. 1 in 4 Canadians identify as caregivers. So I'm really appreciative of including caregiving in this discussion. Certainly we know that ageism, cognitive changes, social isolation, financial dependency, all of those factors that my colleagues have identified are things that can come into play in that caregiving relationship. The only other piece that I would add to this that I think is an important part of this discussion is around caregiver stress and burnout, and how that is something to be aware of as we're looking at systems and processes that are addressing when we get into coercive control, harmful behavior, and that we may have caregivers who started with the best of intentions and who move into other areas of concern and legality around coercive control. And so this is where supports for caregivers, education, and also the components around preparation for all involved are really important to ensure the health and well-being of individuals who might be subject to coercive control.
Thank you so much. So let's stay on that question of disability and vulnerability for now, because I think there's a lot to be said around this. So I'll start with you, Kurt, and then you've touched on this a little bit, but how do disability, dependence, and psychosocial factors shape someone's vulnerability, and why are these dynamics so overlooked often?
Yeah, so I would say the first is about how the system designs independence. So in Canada, an adult with an intellectual disability often relies on income support that is below the poverty line. They often live in housing arranged by others. People with disabilities often have a substitute decision maker for finances or personal care. And none of that is coercion in itself, but it builds a structure of dependence that a controller can step into and exploit. So picture this. So an adult with an intellectual disability has her income support flow through a provincial agency, for example. Her housing comes through a second, her transportation through a third. Her decision-making authority sits with a guardian appointed by a court. A controlling sibling can step into any one of those streams, and the rest of the architecture is already there. So the controller does not have to build the dependence. The government built it. So the control is already half built by policy. And so that like the implication is that addressing coercive control of persons with intellectual disabilities means looking upstream at the upstream architecture of dependence. So not only the individual perpetrator, but like we can prosecute every controller and the structural problem will remain. So my second point would be and cut me off if I'm taking too much time. But the second point is about why this is invisible to professionals. So when a person with an intellectual disability ages, professionals tend to see the disability first and the older adult second. So they assume that limits on choice are clinical, not coercive. And a family doctor, for example, sees a 75-year-old woman with a mild intellectual disability who stopped attending her social programs. The doctor records it as a cognitive decline. The actual cause is that her adult son has moved into her home and is restricting her contacts. The medical record would never catch the coercion. It catches what the coercion produced. And so, and anyways, Canada has lots of treaties and decisions that call this out. And so I will end on this. The third point is what I call the arc of coercive control over time. So, and something I want to leave the panel with is that the dynamic is not a single pre-existing dependency followed by violence. It's a continuous arc with three phases. So, first, the controller often manufactures the dependency in the first place. So and we've talked about them, the Australian examples, like you can isolate people from friends and family, you can take over the legal instruments, they absorb the person into their household, they erode every other relationship until the controller is the only one relationship left. So second, the violence runs during the period of dependency itself, so it often leaves no single discrete active evidence that the criminal law looks for. And third, the harm can continue after the formal relationship ends. So like a former paid support worker or a family member intimidates the older adult into silence about what happened during that relationship. So any legal response built on the intimate partner violence timeline could miss these phases. So coercive control of older adults with intellectual disabilities is therefore not just hidden, it is structurally normalized, and that dynamic is what we really have to surface. Thank you.
Thank you so much. And we'll get into the legal tools shortly in the next question. But Bunny, first, I'd love to hear from you as well. Oh, you're muted.
I'm really grateful I get to follow my friend Kurt because he really, I think, sets up and really follows what I said on the first question is the patterns of control and that life course piece, because I really think that's a lot of what Kurt is really showing us with that concept of the arc, which is that it's baked into the cake right now, and that's really the most important thing for all of us to take away from this conference, for the people in justice, people who are looking at this from a legislative perspective need to understand there's things we need to undo, and the complexity of the particular vulnerability that we're talking about in older adults. And I want to push back on the concept of people being vulnerable. They're vulnerabilized by what's around them. In Quebec, we have the expression "une personne en situation de handicap," and it means the person is made disabled by the environment around them. And conceptually, I think we're talking about the same thing here. So disability doesn't create vulnerability. Systems, inequities, and power imbalances do. What disability can do is increase exposure to control, especially when people rely on others for daily care, for financial management, for communications or access to services. And of course, in the context of people in long-term care and seniors in general, there is often, as has been pointed out, caregivers. And again, it is not to set up the idea that it's always about the caregiver in terms of the violence. In some cases, it is the caregiver that can actually be somebody to support a person with some vulnerability to ensure that they are not taken advantage of. So we know that persons with disabilities are twice as likely to experience violent victimization, because I want to make sure we always remind people that this is data, this isn't theory, and that 23% of women with disabilities report abuse by partners in recent years. Again, under violent victimization, women with disabilities have the highest rates by 2 to 3 times. And that doesn't disappear with age. It often becomes, as we've been talking about and others have been talking about today, more complex. Coercive control in this context can include withholding medication and assistive devices, as we've heard, controlling benefits or pensions, and limiting access to others, as we've also heard. Financial abuse is especially critical here. It's the most common form of elder abuse in Canada, and it's deeply gendered and tied to poverty and dependence. These dynamics are overlooked because older women are largely excluded from gender-based violence policies. And again, in Dawn's work, as you know, Benedicta, we take a life course approach and consider older women with disabilities an important part of the community we're speaking of when we're talking about attention to who needs supports and services. Disability is often treated separately from aging. I think that's another thing that we see very often, despite many conversations we've tried to have to bridge that gap, right, Kurt, in terms of folks from the seniors community seeing the common threads we have in terms of even our voting power. And also significant data gaps. I think especially in Canada, we have some great data, but we don't have very good intersectional data. Certainly organizations like Dawn are very focused on understanding that the intersectional data is the one that's telling the real story about where those gaps are and what kind of things and what kind of measures we need to take to address that. So there's a credibility issue that I think we need to talk about also, right? People with disabilities, particularly those with psychosocial disabilities, are too often not believed. Again, and as Kurt pointed out, folks labeled with an intellectual disability have a similar experience. So invisibility isn't accidental. It's built into how research, policy, and services are structured. I think, again, I know there's going to be another question I won't be part of, but I do want to mention, and I mentioned this to the panelists ahead of this, Dawn Canada are interveners in a Supreme Court case called Alawala v. Alawala. That's before the Supreme Court right now. And that's towards developing a tort in family law that actually relates back to this question of coercive control. Because again, in many cases, that is where these conversations take place, is in family court, where there's no criminal remedy, but the concept of a financial remedy as a tort in family law is one that Dawn Canada and others who've intervened in the Supreme Court are hoping will be the decision. And apparently the decision from the Supreme Court is expected later this week. So I hope to have some good news.
I
We'll
hope so
stop there.
too.
Thank you.
Extremely timely. Thank you so much. And by the way, you can be part of any of the questions you want. Time allowing, if you wish to chime in, please do.
Thanks.
It's a wonderful opportunity for all of us to hear you speak. So I mean, it's not really a shift. We're going to continue in the direction that we've started, like the legal tools that you were mentioning. And let's talk about that and how control can be embedded through them, right? Because we think of coercive control in interpersonal terms, but there are also legal and financial tools that can be used or misused. So I'll start this one with Joanne and then maybe move to Kurt and anyone else who wants to say something. So, Joanne, can you speak to how instruments like powers of attorney can be used to exert control based on what you see on the front lines. And then maybe as a follow-up question, I would love to hear about the challenges that the law and that service providers face trying to distinguish between a legitimate support and coercive control in some cases. But let's start with the powers of attorney.
Okay, thanks, Benedict. So, from the perspective of the Alberta Elder Abuse Awareness Council, we see powers of attorney and other legal financial instruments as some of the most common misunderstood that are connected to coercive control involving older adults. The tools, the power of attorney tools, are intended to provide protection and support, but in the wrong hands, that sometimes they can become mechanisms for that manipulation, that dependency, or financial abuse. We know that at this current time, there is no regulation to monitor powers of attorney. Our case managers across the province of Alberta consistently identify that powers of attorney as a significant form of elder abuse. What makes it especially concerning is that control can appear legitimate on the surface because there is a signed legal document in place. Family members or others may represent themselves as helping, simply managing finances or supporting the decision making, while sometimes in the reality, the older adult may be experiencing that intimidation, pressure, isolation, restricted access to information, or in some circumstances, a complete loss of control over their money or their choices. We hear situations where older adults are left financially devastated, sometimes losing their savings, their access to bank accounts, their property, their land, or their ability to work or to make independent decisions. Beyond the financial harm, the emotional impact is profound. Many older adults are left feeling betrayed, powerless, isolated, and I would use the word broken emotionally because the abuse is often happening at the hands of someone that they have trusted deeply. One of the biggest challenges for both the legal system and the service providers is distinguishing that difference between what is legitimate support and what is coercive control. Families do play an important role, and many people are acting in an appropriate and in the best interest of the older adult. The difficulty is identifying when that support shifts into control, and the older adult's voice then is lost. An older adult may technically agree to some of the decisions, but providers must ask whether that agreement is happening freely or whether it's fear, dependency, guilt, possibly cognitive decline, or pressures that are influencing their ability to consent to what's happening. Many older adults, as I've heard other colleagues here say, do not identify themselves as abused, particularly when the person causing the harm is someone that is an adult child, a spouse, or a caregiver. Another challenge is that the systems often focus on the capacity and the legitimacy rather than the relational dynamics. Some may have legal authority through their powers of attorney, but that does not automatically mean that the actions are free from coercion. Service providers need the training to recognize the warning signs, such as a sudden financial change, some social isolation, restricted communication, fearfulness, unexplained transactions, or the older adult no longer participating in decisions that they previously have managed independently. That's why we feel that coordinated community response teams are so important. Addressing coercive control and powers of attorney requires collaboration between legal professionals, financial institutions, healthcare providers, police officers, community agencies, and elder abuse service providers to ensure that the older adult's rights, autonomy, and dignity remain central. Thanks, Benedict.
Thank you, Joanne. Kurt, anything to add?
Yeah, great comments. Agree with Joanne and that experience. I would say power of attorneys are one piece of a larger legal architecture in Canada that transfers a person's decision-making authority to somebody else.
Mhm.
And guardianship is another piece, and probably the most severe. You've got statutory trustees, public trustees, representation agreements, and even supported decision-making agreements all sit on a spectrum. So the further you move toward full substitute decision-making, the easier coercive control becomes because the controller has the law on their side. So that would what that concretely means is that an attorney under a power of attorney signs an older adult with a developmental disability into a long-term care facility, for example, against their expressed wishes, and she can't leave. The attorney has consented on her behalf. No force is used, and the instrument really didn't work. So if you apply a disability lens, I'll do it quickly to power of attorneys. Um, yeah, we echo what Joanne said that they are widely used and rarely interrogated. Um, Basically, so people are probably familiar with the term and maybe even use them. They're a legal document signed by an adult called the donor that gives another person called the attorney authority to make decisions on the donor's behalf. So there are two main kinds in most jurisdictions in the country. One is for property and finances, and the other is for personal care, including health care. And there are number of structural problems that you could see. So first, capacity threshold runs in the wrong direction. So to sign it, you must have the capacity. So in Canada, that's understand and appreciate test at the moment of signing. So if a person has encountered barriers to their capacity, they shouldn't be able to sign it, or they can't sign it under the law. And most people who would need recognized support arrangements are excluded from the only formal route the system offers. So I would some other problems you would have. It transfers authority by design. It operates, even though it's called like a power of attorney for personal care, it kind of operates as a substitute decision-making instrument once it activates. Uh, it's kind of erases like it can erase the person, right? The power of attorney typically activate when the donor is deemed incapable. And the moment the person needs autonomy and dignity is the moment they lose decision-making authority by the operation of the law. So it's a bit backwards. And the signing moment itself can be a kind of moment of vulnerability to coercion, if you will, because they are signed when the donor has capacity, but kick in when they don't. And a controller can pressure, like it's just it doesn't really it kind of conflicts with what in disability law Article 12, the right to exercise legal capacity, and they're a bit paternalistic, but maybe I'll stop there, but we could get into guardianship and anyways, but I'll stop there for now. Thank you.
There's so much to be said, and I'm
Yeah.
sorry, it's such a time crunch.
Yeah.
But let's move into let's kind of talk about these situations where things get even less clear, where things get a bit blurred, when we're talking about everyday care and family dynamics, family relationships. Because for many of us, support and care in later life, giving, receiving can become necessary. And these situations might create conditions where coercive control becomes harder to identify. So I want to start with Amy for the next question about care and those gray areas. And then maybe we'll move on to Bonnie after that. So Amy, where do you see those lines that start blurring between supportive control, and how can we better recognize the difference where, care and love might actually be masking, and I should put those in in quotes, care and love, that may actually be masking coercive dynamics.
Yeah, I mean, I think this is definitely some of the most difficult terrain that we navigate in our work with caregivers. We see sometimes that there are instances where decisions might be made, under the guise of safety, and that can be a way to mask the removal of choice and voice. And so, I think the most important thing is to have awareness, and for the various folks who've been identified who are in the constellation of an individual's life to be aware of those kinds of red flags, whether that's around monitoring communications, making medical decisions without that conversation, coordination of support, coordinating finances or controlling finances under the guise of helping, limiting contact. The other thing that's been touched on today that I think is really important here is around family conflict, right? And the different perspectives that people can have about what is supposed to or not supposed to happen, whether that is tied to the construct of legal documents or not, right? And the weaponization of allegations, I think, is a risk in these situations that has to be navigated with a lot of care, and also to be careful not to dismiss certain claims or allegations as family drama, right? But to take those things seriously, and for there to be constructs and pathways for those things to be reviewed and addressed appropriately, so that conflict isn't distorting the picture. And then I think there's also a training component here for various professionals who might be interacting with individuals who could be subject to coercive control or may be enacting coercive control, to really increase their awareness, to ask questions, to understand, to the extent that is appropriate in their context, what the legal constructs are around who made the decision. Was the individual a part of this? Some of those things that can hopefully lead to important awareness and next steps if needed.
Thank you so much. So much. Bonnie, anything to add to this?
Absolutely. Thank you. Am I still muted?
No, you're good.
No? Okay. Good. Thanks so much, Amy, for starting us off with your comments. So, Dawn, Canada's research really underscores that care is both essential and a site of power. The line between support and coercive control becomes blurred when decisions are made for someone rather than with them. Access to finances, communications, or supports is restricted, or when safety is used to justify limiting autonomy. A key question is, does the support expand the person's choice or narrow them? This is especially important given the crisis in care we have in Canada right now, because what we have, and we can't not face this, is unmet home care needs, a massive problem with unmet home care needs. Workforce shortages and grossly underpaying caregivers in terms of the important role they play in our economy and in our society. And of course, the increased reliance on family caregivers without understanding the impact on family caregivers. I just lost my mother of 95 years. And that's after watching my sister in her 70s struggling with cancer, being my mother's full-time caregiver up until very recently. And it's quite clear that this idea that families should simply be responsible for elder care without there being any support from the state, from the larger community, and for us not understanding that this is our collective responsibility is a really big part of the problem I think that we're facing. And so when systems fail, families are often left to fill the gaps, and that can increase both the stress and the risk, as Amy was talking, including financial abuse and control. What we also know is that family members are the most common perpetrators of abuse, and that older adults are less likely to recognize abuse when it involves their own children. As hard as these conversations are to have, they must be had. In situations involving sibling conflicts or warring families, the challenge is that concerns about coercive control may be real, but they can also be shaped by conflict, competing interests, or financial pressures. So the goal is not to arbitrate family disputes, is to center the rights, the will, and preferably, and the preferences of the older person. And it's to ensure access to independent, accessible advocacy when needed. And so how important it is to recognize how power operates within both families and systems. And I would just want to add a small thing, which is that Dawn Kennedy has been doing a great deal of research supported by Women and Gender Equality around long-term solutions. And as many people on this call will know, other than Dawn Kennedy, there's very few frontline services or organizations focused on women with disabilities and their needs. So one of the things that Dawn Kennedy has identified and is very focused on are peer support models, but they're more complicated to apply in long-term care and caregiving in congregate situations where activities are monitored. But Dawn Kennedy is very focused on using this model at the community level where women with disabilities need to be actively involved in supporting other women with disabilities in seeking support. Complex and very few frontline services that are directed at older women and women with disabilities are understood that it's the kind of outreach that's needed. So moving away from institutionalization is our shared goal here, but we need to think ahead to building communities where people can age in place, safe and supported. Thank you.
Thank you both. Looking at the time, I'm going to move to my next question, and this one will be for Kurt. But brief reflections here, given the time. I wanted to talk about the best interest defense. Actually, I think someone asked the question in the chat box while you were speaking earlier. So this is something that was proposed in Bill C 332 at first reading a couple of 3 years ago, and it's part of England and Wales criminal law on coercive control. So does that best interest defense help, or does it create more risk for older adults, particularly older adults with disabilities? And what are the risks of that defense, especially for people who experience disabilities?
Okay, here's my streamlined best interest
Thank you.
defense answer. So the short answer is that a best interest defense in coercive control um, creates more risk than it resolves with a particular force for, like you said, adults with disabilities. So the three quick risks. So first, the defense actually inverts the burden of the defense. So what I mean is a coercive control offense punishes a pattern, isolating someone, monitoring them, controlling their money. So none of those acts are criminal necessarily alone. So the pattern is the offense. A best interest defense invites the controller to say, I did it for them. And so, quick example, son who isolates his mother because he has decided he knows what is best for her, the daughter who moves her father into long-term care because she has decided he can no longer manage alone. Both in those examples, they may testify their actions were in the parents' best interest, but both may be telling the truth as they see it, and that's the problem. The defense doesn't filter for bad faith. It writes the controller's own story into the statute. Second, the defense carries the historical baggage of the medical model of disability. So I could go on a long tangent here. I won't, but encourage you to look it up, and we would adhere to the social model, the human rights model of disability, which works with the medical model. Anyways, but for so basically, what to say? Basically, when applied to adults with disabilities, the best interest standard has overwhelmingly been used to justify removing choice and not protecting it. So, in disability rights vocabulary, what's being removed is something called the dignity of risk, and which is the right to make decisions that carry uncertainty, even decisions others wouldn't make for you. So the right to take a chance is part of what it means to be a person and a human being. And a best interest defense is coercive control law, like coercive control law threatens to deny it. And I will skip. The third point is basically the defense doesn't match the reality of how coercion control happens to older adults. Won't get into that now for sake of time.
Thank you so much. I feel like we should almost have an event just to talk about this. I want to hear everything. Okay, let's move on to Joanne with the next question because I want to hear about the realities on the front line. And Joanne, with your organization, you very much are on the front line of elder abuse prevention and intervention. What are, according to you, the biggest barriers to recognizing and responding to coercive control when it involves older people, especially, as you mentioned earlier, in rural communities? Like, what tends to get missed?
So, from our perspective, working in rural, small communities, indigenous nations, many people understand that elder abuse exists. The challenge is that coercive control often gets overlooked because it's not obvious and it doesn't necessarily get identified in everyday life. So one of the biggest barriers that we find is that older adults often do not want to have service providers or formal interventions, even when we know that coercive control is happening. And in many of those situations, older adults are faced with an impossible choice: accept the harmful stuff that is happening or risk having no support at all. So in those rural Alberta communities, coercive control is often masked by familiarity, longstanding relationships. Workers may know the family, the caregiver may be well regarded locally, and the older adult already may be socially isolated in ways that have become normalized over time. Because communities are close-knit, abuse family conflict or caregiver stress or just how families function, rather than recognizing that it is an ongoing pattern of control. The majority of the challenge is that coercive control rarely, and we all know that, presents as one clear incident. Frontline workers often see that pieces of the situation, missed appointments, unexplained anxiety, financial concerns, those are signs that are always not connected into a broader pattern of coercive control. What happens is the absence of that physical violence also leads to under-recognized, even when the older adult's autonomy is being steadily reduced. Rural geography creates yet another layer. We have limited services, we have transportation barriers, and we have fewer supports. And meaning that older adults may heavily rely on the person that is causing them harm. That dependency is kind of wrapped into caregiving, and it's one of the most difficult realities for frontline staff to face, particularly when it's an adult child or a family member, and they have and are the support and that source of control. Workers are often balancing safety concerns with the reality that removing that support may leave the older adult completely isolated. Also, in cultural and generational norms, it can also influence how abuse is understood. Some older adults may not identify controlling behavior, such as that financial control or restricting social contact. Or making decisions on their behalf as abuse, particularly when those behaviors are framed, as we've heard, in protection, caregiving, or within family relationships. From an Alberta frontline perspective, the issue is often not a failure to notice the individual warning signs, but difficulty recognizing when those signs together represent a sustained pattern of coercive control and the loss of autonomy, especially when there's no obvious crisis moment that is prompting any kind of intervention. So that's what we're seeing, Benedict.
Thank you so much for this. It's really interesting to hear about that. And now, we've talked a lot about challenges, so I guess let's shift our focus a little bit and turn to more of how we respond collectively to try to address this issue. So this next question is going to be for all of you. Let's give it, no more than 2 minutes per person if possible. I know I'm asking for very difficult things, but what does effective collaboration across sectors look like? So we're talking justice, disability sector, caregiving, community services. What does that look like to respond to coercive control of older people effectively, meaningfully? So let's start with Amy, from your caregiving experience and perspective.
Sure. So I think one of the things about effective collaboration is we need to look at, as best as possible, how we can have common language, but also how we can recognize different forms of language or terminology that people may use from different contexts so that we can work together around alignment on definitions and those kinds of foundations. I've seen people in the chat, and it's come up a few times in our conversation here around recognizing caregivers. The core of our work is around the kinds of challenges that caregivers are facing and the importance of collaboration across health and social care systems, giving caregivers the support they need. I know that that's not core to this discussion, but I do think that it is part of the collaboration question, and making sure that we are building and implementing better systems to facilitate that collaboration and coordination of care across all the settings where that might be occurring, because caregiving itself can be extremely socially isolating and lead to a lot of financial and other challenges for caregivers. I would just highlight a couple of other things quickly. Co-located and coordinated services, I think, are hugely important. Shared intake processes and joint case conferencing, I think, can bring to light different forms of awareness and flags in a system that's fragmented. I think that fragmentation can actually enable coercive control to continue for longer. So the more we coordinate and communicate together, the better. And engaging community organizations and the critical convening role that they have to play in having that trust, that coordination, and sometimes that can be a safer place for people to go to support because they may not have the trust in some formal systems. So community organizations can be really key, especially for individuals from racialized, Indigenous, newcomer communities who may need safer places to go to get the support that they need.
Thank you. Bonnie, any further comments from your perspective?
Yeah, thanks very much. And again, thanks, Amy, for setting this up so well with your comments. So I think it's very clear that the biggest barrier is not a lack of effort, it's fragmentation, right? Right now, the system is addressing elder abuse, gender-based violence, and disability, but not together, right? One of the things Dawn Canada finds itself very often is that we're the connector between the disability and the feminist space, and often other spaces as well, because we actually repositioned ourselves as an intersectional human rights organization in 2020, really based on the realities of gender-based violence for women with disabilities, again, across the life course. Effective collaboration means moving beyond coordination to integration. That includes a shared understanding, as Amy already said. I would apologies, I got my colleagues mixed up, but I was going to say a shared understanding of coercive control, including financial abuse and life course violence, embedding disability in an intersectional lens across all sectors, and creating clear, accessible pathways so people are not navigating silos. Because that's all we do. A lot of us, right, is those silos. And really, like I said, it's a place where the government really has to move beyond the concept of GBA plus, right, to intersectional practice in the way that programs are developed, the way that funding is organized, the way that roundtables are brought together. I was at a roundtable for people with disabilities and another roundtable for people in the GBV sector. And it's the other point that I wanted to make sure I covered today, which is that a really good example of something good that is happening is what Minister Champagne announced in the fall, which is the new Financial Crimes Agency and the Code of Conduct for the Prevention of Economic Abuse. Now, again, on its own, it's not the only solution, but it's a very good example of what could be the kind of approach, that integrated approach. Again, one of the mistakes I saw in the consultations was there were two separate consultations, and the only one who was at both consultations was Dawn Canada, right? So it's a good example of places where, like I said, the intentions are good. And really, like I said, it's about opening up those silos. I think there's lots more to say to this, but I do think we needed to give some positive examples of things that are starting to happen and opportunities. I'll stop there. Thank you.
Thanks so much. Joanne, anything to add to this?
Just saying the same thing that Bonnie has just said, that when we work in silos, that's not helpful. if we're working collectively, it creates relationships between organizations before the crisis happens. And I think that's pretty key. So when there is a concern and there's already the trust and the communication and a clearer understanding of who can pitch in and who can help, that's what makes a difference for people. That's what makes a difference for older adults.
Wonderful. And Kurt, last words on this question, at least?
Very, very quick. There is, I think, collaboration can start effectively. Collaboration starts before a crisis. I think there's opportunity for the disability rights movement and sector to work with elder abuse realm. And there's actually in the works right now the beginnings of a international treaty on the rights of older persons. I expect the right to exercise legal capacity and conversations around it to be in that. So it would be great for these groups to team up and work together at the international level. I think that um, you know. Anyways, the two like paid support workers across disability services, home care, long-term care need shared training on coercive control and the language, the human rights language. There are very different vocabularies, and sometimes that they miss each other. And I'll leave it at that.
Well, you know what? Let's stay on that topic because I had the question. You did mention that earlier as well, the international rights framework. So how can an international human rights instrument like the convention, the United, my goodness, United Nations Convention on the Rights of Persons with Disabilities, how can that help strengthen our understanding and our response to coercive control? And then how does a potential convention on the rights of older people fit into that? Do you
Okay.
see the potential?
Uh, I would say that the acronym for the Convention on the Rights of Persons with Disabilities is CRPD, and I would say it does three things for this conversation that maybe domestic law doesn't address. And one, it gives us a complete framework, or mostly complete framework, on Article 12 on legal capacity, which is the right to exercise legal capacity. So basically, the right to make decisions no matter what. So your record, we don't conflate mental capacity and legal capacity. You can make decisions no matter what with the right supports. Um, in all circumstances of life. It has the Article 16 on freedom from exploitation, violence, abuse, 19 living in a community, 25 on health. They're all interlocked, interrelated. So the convention recognizes the patterns that domestic law treats as single offenses. So that's my first point. My second would be that the CRPD committee's uh, uh, concluding observations of March 2025, which is essentially a decision or a judgment in international law that's non-binding, but what we should strive for, and Canada has said that they are bound to, told us to develop a plan for deinstitutionalization and to move forward on a supported decision-making regimes across the country, and all of these, everything that touches basically the landscape of coercive control for adults with disabilities in the country. And maybe on the older persons convention, now that the international process has formally begun, so they had their first hearings. They haven't got into the article by article pieces yet. The next meetings are in July, if you're interested. And I think by article will start in the fall in Geneva. And the UN Human Rights Council adopted a consensus to draft this or legally binding instrument for states that want to be a party to it. Um, Cautiously supportive. I think there's still some a protection gap, and I really think that's why this convention should be developed in active consultation with persons with disabilities, the representative organizations, and elder abuse groups, older adults with intellectual disabilities. have been left out of almost every other human rights treaty that has been negotiated to date, and we can't let that happen again.
Thank you so much for this. And yes, we are very much following closely the development of that Convention on the Rights of Older Persons. So we'll see what happens in the next few months/years. Okay, last question. I think we're doing okay with time. I wanted to make sure we had some room for questions from the audience. So I'll ask that last question to all of you, and we'll do again kind of a quick round in 1 or 2 sentences, which I know is hard. Let's focus on solutions and, the way forward. If you could prioritize one concrete action to better address coercive control of older adults in Canada right now, and it can be policy, practice, public awareness, training for caregivers, what have you, what would it be and why? Let's start with Amy.
Well, I'm going to lean into education and not just for caregivers, definitely for caregivers. I think that's the single most impactful thing that we could do to help them to understand what these behaviors are, what they may need to recognize as warning signs within themselves or within the broader circle of care constellation of people around the person for whom they're providing that care. But I also think that education is important for people providing health and social justice care to really understand what this looks like, what the pathways are to respond, and raising that awareness across these systems. I think I'll pick that as my one thing, even though I have a couple more on my list. Others will cover.
Thank you. Joanne.
So, what I would say is if I could put one thing that would be action, it would be to formally recognize coercive control involving older adults within policy, legislation, and that professional practice framework across Canada. I think that would be ideal.
Wonderful. Efficient. I love it. Thank you. Kurt.
I would say, let's see, this is tough.
Yeah.
Reform, okay, straight up, maybe it's not tough. Just reform Canada's legal capacity laws. Just do that. But move from substitute decision making to supported decision making, with safeguards in every province and territory. Why? Because coercive control of adults, older adults with disabilities, does not happen in a legal vacuum. It happens inside an architecture of guardianship, powers of attorney that have already transferred decision-making authority away from the person. So the controller does not have to overcome the person's autonomy. The law has done that work first. Full stop.
Thank you. And last but not least, Bonnie.
Wow, it's hard to follow all my amazing panelists. And I will say it starts with, I think, what I heard first, which is, so Dawn Canada's, like all the things that were in the question are important because they're all about systemic challenges, right? Everything you mentioned, policy, practice, public awareness, support and training of caregivers. Our 4 pillars at Dawn Canada in this order, however, are research. Second pillar is education and learning. We used to just say education, but it's education and learning now. Policy, and the last one is advocacy, in that order, and for an important reason. Research is telling us plenty, and we've got lots of research. I think all of us understand the research is pointing to something. And in my mind, you can't affect good change in policy or in practice unless you make education and learning the next step. So I have to say that I think education and learning is going to inform everything that happens after that. The research is there. We don't need affirmation that elder abuse and coercive control are a problem. But what we do need is to better understand, so learn, and then educate both legal systems, policymakers, and of course, so that when we do our advocacy, we're doing it based on what we know.
Thank you very much. Well, thank you so much to the 4 of you for this fantastic panel. I feel like there's so much more to be discussed. We could explore in individual events for a long, long time, and maybe we will. I did encourage people to ask their questions in the chat box ahead of time. We even received some early questions before the event, so let's go through some of them. We have about 15, 20 minutes But I want to say before we even get into the questions, there has been a lot of feedback from people thanking you individually for recognizing, some of the scenarios and the realities that you outline, the coercion in institutions or the burnout of caregivers and the many burdens that can land on someone's shoulders when they are placed in a caregiving situation without any support of any kind. So I think this is really a question that is affecting a lot of people and touching a nerve. Um, so let's see, what do we have for questions? There's someone, and I don't know if anybody will feel comfortable answering this one, but somebody was asking about coercive control. If you are a healthcare worker, you are in a position where you might observe something taking place. How does one intervene or expose it without creating additional problems for the person they care for or for themselves? Is that something that any of you feel? Because the healthcare world is a bit of a different.
I think it is probably better answered by somebody who works directly in healthcare, including across, sort of the legal aspect of it, the other aspects of it.
Yeah.
I think Amy might be somebody who has something to say about it. I certainly think the important thing is that if you have knowledge of somebody's experiencing abuse, you have to find some way to do something. You can't just look away. And I think we all understand that. And it will depend on the circumstances, whether that's something that you can do through the institution where it's occurring or outside that institution. That would be one of the first things that I would say, is that you have to look at the setting, and then from there, what is or isn't there. And then, if you can't find something inside, then find somebody outside the setting to work with you and the person who's at risk.
So I just wanted to add then that in Alberta, we have the Protection for Persons in Care Act as an external body that takes those referrals if circumstances like that exist.
The only other piece I would add to that is the vast majority of individuals are not in a congregate setting, right? Most people are aging in place, living at home. There may be, though, home care workers or other individuals whom they are encountering. And so I really appreciate Bonnie's comments around, what are the structures within your organization, your institution around those reports, or there may be also professional guidelines depending on the type of healthcare provider who's interacting, who may have different professional standards that they need to meet around reporting abuse. But I think we do need to recognize that we've talked a lot about social isolation, and the things that may come up in that home care context are important to consider as well.
Thank you very much. The next question is addressed directly to Bonnie. One of our attendees would like to, or asking you to expand on how older women with disabilities are targeted for coercive control, looking at it through that intersectional lens you were speaking about.
Well, I was going to say, I think there's no one answer to that question. It's a good question, and I appreciate that you focused on women in the context of gender-based violence. And I would say, again, a bit like the last question, it depends a great deal on the circumstances, what the best approach is. And so, in some settings, as I said, direct intervention is what we want. Can you just repeat the question for me, Benedict? I don't want to go off on a tangent and not get it.
Of course. The question was, would you be able to expand on how older women with disabilities are targeted for coercive control through an intersectional lens?
Okay, go back to the intersectional lens. I think it's really important that you bring up the intersectional lens, because I do think, like I said, the experiences that different women from, for example, different intersecting identities would have is quite important. I think of, and I don't mean this in any way to criticize of folks who are immigrant, but I was going to say, in many cases, when you're talking about older women who are living at home, in the example where the family members will speak English, but the older person doesn't speak English, for example, where they're completely dependent on their family for outside communication, for anything that they need. That's a very important example, I think, of an intersecting situation. Of course, in my own work, in terms of the people on my team, I have Evelyn Hutchins, who's the Director of Indigenous Initiatives, who's been a very powerful advocate for access to financial resources for Indigenous women. And in that work, of course, she was able to and would be able to provide plenty of examples of situations where Indigenous women, either on reserve or in community for different reasons, are very vulnerable. I think another situation that I can speak of without too much detail would be the situation of a woman who is, for example, married to a service member who is on a military base. This is another situation that many people would not think about, but that creates a very different situation when there's gender-based violence in the home, including an older woman who may be on, a military base. So I think the intersectional example is a very important one to think about. I think cultural safety is important to understand, that cultural difference in terms of understandings of what gender-based violence is and isn't are all part of what we need to think about. And again, it is one of the reasons why there is no sort of cookie cutter response to this, and why, again, the idea of approaching this across sectors, across communities is really critical. Thank you.
Thank you very much. I do have actually two questions that kind of one flows from the other, but I'll start with the first one and I'll open it up to the group. Stephanie is asking, is the hope that the term coercive control will encompass all types of elder abuse and make it a crime? And will this help make emotional or psychological mistreatment illegal, not just physical or financial abuse where evidence is easier to obtain?
I would just remind folks of the Alawala v. Alawala case. And the example of the Alawala v. Alawa case, in terms of this is an example of coercive control in a very specific context where the remedy that we're trying to develop is a financial remedy in family court. So I think there's lots of other people who should speak to this, but it did make me think of the Alawala case and why the tort and family law is one of the remedies that we think would be one of the important and more realistic ways to approach the idea that it's not always coercive control in a context that requires another type of intervention.
So Benedict, I'm sure Heather can speak to this as well, but when we look at Bill C-16 that is looking at the gender-based violence and the ask to include relative as part of that coercive control legislation, part of that criminal aspect of things, that would make a difference from a frontline service provider perspective. Being able to report that to the RCMP, identifying those issues as coercive control would address the issue of elder abuse in some of those things that are not so obvious, like a physical abuse, but some of those other pieces. So that's where I would come from in terms of the Bill C-16.
Thank you. Any other comments on this? Otherwise, Kurt, maybe?
I'd agree with Bonnie and just say, like, coercive control, it captures one specific thing, and that's a pattern of conduct used to dominate another person. It's not a catch-all for every other form of elder mistreatment. It fills a specific gap where harm is the pattern itself, not a single incident. So
thank you. And I think that might actually touch on the follow-up question from that same participant who was saying I'm curious if there is a fear or a worry that the terminology of coercive control may dilute the terminology of abuse.
I want to add something that sort of ties another thing that came up on this on the panel, which was interpersonal. So in the GBV space, everybody uses intimate partner violence. And one of the things Dawn Canada has said repeatedly is that term is very limiting, because intimate partner violence in the legal context is very specific in terms of what it suggests, which is a specific type of sexual assault. Whereas interpersonal violence, which is much more prevalent, in fact, in many instances, is a broader term, but one that is actually a better one to define indeed interpersonal violence as opposed to intimate partner, and coercive control. Like I said, while there's I don't know if I'm making the point well, but that's where I'm trying to go with this. Somebody else should jump in and help me.
I can try. I think I would argue the opposite, that it sharpens, and how does it sharpen it? It names a thing that people have been struggling to name for many years. And as long as it's not used as for everything, that remains the case.
Thank you very much for this. Now
Thanks, Kurt.
I have a couple of questions that I've seen come in, and I know they're probably going to elicit some strong reactions in you, but I think it's important to maybe tackle it. Um, there's been several people asking, why are we not recognizing older people as a group, as vulnerable like we do with children? Why isn't there a duty to report like there is with child abuse? And yes, I can see, Bonnie. I know exactly what you're thinking. But you know what? Let's talk about it because I think that's a question that gets asked often. So let's provide an answer to people for that. Who wants to start? Bonnie, are you feeling so moved?
I was going to say maybe I should start because this person obviously heard me say at the front end of this a wonderful panel that the concept of vulnerabilization is something that we really have a problem with. Um, and again, I don't not understand why the person is concerned, but I will push back on the idea that concern equals vulnerability, right? I think, the whole concept of autonomy is one that we all need and value as individuals and need to respect that every individual has the right to. Indeed, when, Kurt was talking about the decision making, and I want you to jump in here, Kurt, please save me again. Because again, I do think, like I said, this concept of vulnerabilizing people is part of the problem, right? Instead, we need to be looking at what are people's needs so that there is no vulnerabilization that is unnecessary. I mean, yes, the sky is not going to fall, but you could be walking by a building and something falls off the building. One is real, one is imagined. Both both concepts are, anyway, I'll stop there. Jump in, Kurt, please.
Yeah, no, totally agree. So, like, designating adults as vulnerable imports, it basically imports the same paternalism that gave us institutionalization, forced sterilization. Every one of those decisions was framed as protection. The susceptibility is not in the person, at least in the movement I work in. It is in the system around the person. So rather than a duty to report, I think we need a duty to support. And and that rhymes. I'm going to use that going forward. I like that. I think it works.
I'll maybe just chime in here. It's, ageism has come up as a theme many times in this conversation, and I think it bears repetition here. I can't remember who said it earlier in this discussion, but it's definitely a conversation we have in caregiving circumstances around people being able to make choices that involve risk, right? We all make choices that involve risk every day, right? And it doesn't mean we can necessarily create risk for other people in a way that could lead to criminality or whatever else. But we get to choose in so many aspects how we live our lives, and that is part of being a human being, being autonomous, being sentient. And so, when we think about this in terms of caregivers often feel like decisions in health and social care are foisted upon them. And part of what we're looking to do within the context of caregiving is to recognize them as a part of the care team, right? And especially when we talk about things like hospital to home transitions, where the caregiver will be relied upon very heavily. Have they been involved in the decision around that? Well, the same is true for so many aspects of people's lives. People want voice and choice, right? They want to be able to carve out to the best of their circumstances, their life the way they want to live it. And so I think we just if we can rally around that, then we can look at what those supports are. And I like Kurt's term as well.
I think we just coined a new catchphrase for future advocacy. Joanne,
I think
last word?
just to say the same thing. So our field is specifically elder abuse, and case managers across the province support older adults. But it is always says that the older adult drives the bus. And I guess that's what it comes down to, is making sure that they are in charge of what's going to happen. We can present options, ideas, but they drive the bus.
Thank you so much. I think we are just a few minutes away from the end of our event, and I don't want to go over time because I know it was a long day for many of you already. So thank you so very much to the four of you for accepting to participate today and for bringing such astute commentary to this whole question. I hope it brought clarity to many of our audience members today. And I'll say it right now, CNPEA is more than interested in working on these topics with you and exploring this, meaningfully together. So keep that in mind. Put that in on the back in the back burner for whenever you have a minute to chat with me. I wanted to thank Rayanne Rideout, who is not visible, but maybe she can come on the screen for minutes because she's been helping me, pull this event together, and she was in the back end keeping everybody happy and connected. So thank you so very much to Elder Abuse Prevention Ontario for being our partner. Similarly, Dementia Justice Canada and Heather Campbell Pope, who has been the engine that kind of got this whole thing started for us, at the end of 2025 and really kind of brought many of us together to start talking about this and start thinking about bringing this question to the forefront. So thank you both. To our presenters earlier this morning as well. I don't know if you're still around, Margaret, but if you are, thank you for bringing us all on board on the same level with your presentation. And just a couple of things. Kurt, thank you. You've put your contact information in the chat box. Rayanne is also sharing some information in the chat about upcoming events, because as I mentioned, this week is Victims and Survivors of Crime Week. Now, if I could just make this full screen, there we go. And so Elder Abuse Prevention Ontario is hosting also an event this week for this special week. It's going to be about legal dimensions of elder abuse in Ontario, and it's taking place on May 14th, so in 2 days. And it's taking place from 9:30 a.m. Eastern Time to 2:30 p.m. Eastern Time. So if you want to learn more, check out their website or look in the chat box for the link to participate. And while we're on it, we do have a few things coming up that might be of interest to you. At the end of May 21st, we'll be talking about the mental health impacts of fraud in older adults with the Canadian Coalition for Seniors' Mental Health. Again, you can register. This one is a simple webinar of 1 hour, so a lot less time commitment. For those of you who are interested in a multi-day risk assessment training for the HOPE tool, Harm to Older Persons Evaluation, this is taking place at the end of May with Elder Abuse Prevention Ontario. Again, I know I'm going through this fast, but all the information is on their website, eapon.ca. This one is limited because it's a full training, so you might want to register right now if you are interested. And finally, in June 15th is World Elder Abuse Awareness Day. We're holding a special event a few days early on June 10th. So we'll be sharing more details very soon. But if you follow either EAPO or CNPEA, you will not be able to avoid information. You'll hear about it. That's a promise. I believe that is it for us today. Again, if you want to share your views, what you gained, what you thought, where you disagreed with us, we have a survey link. We encourage you to take that survey and let us know. We want to hear it all. Thank you so very much to all of you for staying with us for this entire event. And we'll see you next time.
Thank you.
Thank you.
Thank you very much. It was a real pleasure.
Thank you, Bonnie.
Merci.